Court does call the case. People versus Edward LaRue.
We're ready in that matter, Your Honor.
This is where everything begins, and it already signals a controlled procedural courtroom. But underneath that calm tone is a case built on pressure, manipulation, and consequences. Edward LaRue isn't walking into a chaotic trial. He's stepping into a negotiated outcome. That means decisions have already been made behind the scenes. Deals have been discussed, risks have been calculated, and right now, what we're watching is the formal execution of that deal. But here's the key tension. When someone pleads guilty this early, especially in a case tied to communication with a victim, it usually means the evidence is strong, or the stakes of fighting it are even worse. The court is about to confirm whether this plea is voluntary, informed, and legally sound. That process might sound routine, but every question the judge asks is designed to eliminate future appeals, protect the record, and lock this defendant into accountability. And as this unfolds, pay attention to how LaRue answers, because hesitation, wording, and tone can reveal far more than just guilty or not guilty.
Just appearing to get people.
Good morning, Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Edward LaRue. Mr. LaRue, please state your name for the record.
Edward Robert LaRue.
I have before me a plea form. It indicates that the defendant would be pleading guilty to an added count to the malicious use of a telecommunication service. That's a 6-month, maximum 6 months incarceration, $1,000 fine. Upon his successful guilty plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement, counsel.
That is our understanding as well, Your Honor.
Mr. LaRue,
Yes, Your Honor.
please raise your right hand, please. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record.
Edward LaRue.
All right, sir, it is this, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of malicious use of a telecommunication service. That is a misdemeanor, punishable by up to 6 months incarceration or $1,000 fine plus court costs. You understand that, sir?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Plead guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I understand.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, sir.
This is one of the most critical legal moments in any plea hearing, and most viewers miss how serious it is. When the judge confirms that LaRue is giving up his right to appeal, that's not just a checkbox, that's a permanent door closing. What does that mean in real terms? It means once this plea is accepted, LaRue cannot come back later and argue that the outcome was unfair unless there's an extreme legal flaw. No second chances, no "I changed my mind," no revisiting the evidence. And notice how quickly this exchange happens. A simple "yes, sir." But behind that response is a massive legal consequence. This is exactly why judges go step by step. Because if even one of these rights isn't properly explained, the entire plea can be challenged later. Now here's where it gets interesting. LaRue admits he will be on probation for a separate domestic violence case. That connection matters. It shows a pattern, and it also raises the stakes. Because any new violation, especially involving the same victim, can trigger harsher consequences across multiple cases. At this point, the courtroom isn't just processing a plea. It's building a record that could affect this defendant's future far beyond today.
Are you on probation or parole?
I will be upon release. I believe I have 24 months probation for my domestic violence case.
All right, let me ask you this. On the date of July 24, 2023, were you on probation?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense, sir?
Yes, Your Honor.
July 24, 2023, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do that makes you think that you're guilty of this offense?
There were several phone calls I made from the jail to the victim on my domestic violence case, Amy Burberry, that could be seen as discouraging showing up for court to dismiss my case. So that's why I'm pleading guilty.
All right.
Nothing threatening or intimidating, but maybe discouraging.
All right. But in doing so, you were doing so in a way to harass her in a way to make a decision. Isn't that correct?
I wouldn't say to harass her, but we did have a no contact order.
All right.
Mr. LaRue, you're trying to put pressure on her not to come to court. Is that correct?
Yes, sir.
Thank you, Mr. Brown. All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Satisfied, Your Honor.
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
September 18th at 12 p.m.
September 18, 2023, 12 p.m. That is before me.
The plea is accepted, sentencing is scheduled, and just like that, one chapter closes, but not without leaving behind a critical detail that could change everything. Right after locking in the sentencing date, defense raises something subtle but powerful. The victim wants the no-contact order lifted. That's a major shift, because earlier, this entire case was built around the defendant contacting that same victim in violation of court rules. So now the court is facing a contradiction. On one hand, there's documented behavior showing pressure and boundary violations. On the other hand, the victim is signaling a willingness to remove restrictions. But notice how the judge handles it. Calm, controlled, and procedural. He acknowledges it, but doesn't act on it immediately. Why? Because lifting a no-contact order isn't about what one party wants in the moment. It's about long-term safety, legal consistency, and risk assessment. This is where courtroom decisions become less emotional and more structural. Even if the victim's voice is heard, the court still has to protect the integrity of the process, and sometimes that means not giving immediate relief.
Bond will continue. Thank you.
Yeah, Judge, I just want to address one thing because I want to make sure the victim knows that her voice is being heard. She does want the no contact order lifted. She's not here today. I did want to tell the court that. However, I think that's something that would be more, we should approach at sentencing because there's a no contact order still in the 14A1 case. But I did want to make mention to the court so that she knows that her voice is being heard today.
All right. Very good. Okay. I will note that.
Thank
All
you,
right.
Judge.
Thank you. Court does call the case. People versus Isel Nellen.
Nicole,
We're
on
ready
behalf
now.
of the people.
We're ready in that matter.
All right.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Nellen, who appears from the Washtenaw County Jail.
Mr. Nellen, can you state your name, please?
Isaiah Nellen Jr.
Thank you. All right. What are we doing?
Your Honor, today is the date and time set for the probable cause conference. My client respectfully requested this matter continue to preliminary examination. We're going to ask for 2 weeks and some investigation that we need to do in order to be properly prepared.
Okay. I have the 12th or the 19th. Which would you prefer?
The 19th would be best.
All right. Any objection from the people?
No, Your Honor.
Preliminary examination will be set September 19th, 2023, 9 a.m. That is before Judge Freshour.
Thank you, Your Honor.
Now we shift into a completely different phase of the courtroom. This is no longer about a plea. This is about strategy. The defense is requesting more time before the preliminary examination, and that tells you one thing immediately. They're not ready to move forward yet. In legal terms, this is a delay, but not a weak one. It's a calculated move. Preliminary examinations are critical because they determine whether there's enough evidence to move the case to trial. So asking for more time usually means one of two things. Either the defense is still investigating or they're trying to negotiate behind the scenes. And notice how smoothly this gets approved. No objection from the prosecution. That's important. When both sides agree to a delay, it often signals that something is happening outside the courtroom, possibly discussions, evidence review, or even early deal positioning. This is how cases evolve quietly. No drama, no confrontation, just controlled movement toward a stronger legal position.
Thank you. Bond will continue.
Thank you.
Court calls the case, People versus Yanesia or Yasina, maybe, Cox.
Yes, that's me.
Alex Chabalowski for the people.
Andrew Banis, Assistant Public Defender, with and on behalf of Ms. Cox. Ms. Cox, could you state your name, please?
I'm Yesenia Cox.
Do you have a camera, ma'am?
I do. 1 second.
More than a second. Just saying.
I'm sorry.
It's okay.
I have an after. So my bad.
No, it's okay. Okay. No, you're doing good. Just do it. All right. What are we doing?
Your Honor, Ms. Cox is waiving her right to a preliminary examination for hopeful resolution up in circuit court. I believe she is HIDA eligible with prosecutor consent, but in short, she's waiving her exam.
But the prosecutor's consent is not part of the waiver at this point. Is that correct?
That's correct. It's not, there's no agreement at this time.
Thank you. All right, Ms. Cox, you've heard what your counsel's indicated, that you're waiving your right to a preliminary examination.
That's correct.
All right, you understand that that is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand.
And you understand you'll not have that proceeding and you'll proceed to circuit court for further resolution.
I understand that.
People also waive their right?
Yes.
This moment might seem procedural, but it's actually a major turning point in the case against Yesenia Cox. By waiving the preliminary examination, she is giving up the opportunity to challenge the prosecution's evidence at this stage. Why would someone do that? Because sometimes the defense already knows what the evidence looks like, and instead of fighting a losing battle early, they move the case forward to a higher court where more strategic options exist. But here's the trade-off. Once you waive this step, you lose a chance to test the strength of the case publicly. You're essentially saying, let's move this forward and deal with it later. And notice something else. The prosecutor's consent is not part of the waiver. That means there's no deal yet, no agreement, just movement. This is a high-risk, high-strategy decision. Because from this point on, the stakes increase, the pressure builds, and the room for error gets smaller.
Preliminary examination having been waived, defendant is bound over to circuit court on all three counts. Mr. Banis.
Your Honor, I acknowledge receipt of the information. Ms. Cox waives formal reading and stands mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set.
October 5th at 1:30 p.m. with Judge Slade Thursday.
October 5th, 2023, 1:30 before Judge Slade Thursday. All right, bond will continue. All right,
Thank you.
thank you.
I have a question.
Okay,
Is it possible to postpone that by a week or so or not?
you can talk to your counsel and he'll have to do something in circuit court. That's the only date we have for Judge Slade on Thursday. So you have to talk to counsel and he'll be able to probably work that out with the court up there.
Understood. Thank you.
All right, thank you. The court does call the case.
Sandra White on behalf of Alicia Williams. Ms. Williams, can you state your name?
Oh, hold on. He was unfrozen. Now they're frozen again. All right, I'll pass it again. Oh, yes. Well, hold on. You shut the video.
No.
Oh, something happened. Okay, I'll pass it. And as soon as they can get him back, we'll deal with it.
Okay.
Court calls the case. People versus Jason Hernandez.
Alex Chabalowski for the people.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender for Mr. Hernandez.
Mr. Hernandez? You have it.
Your Honor, I was on the phone with Mr. Hernandez 11 minutes ago and gave him the Zoom information. If Your Honor might consider passing this matter, I can see if he's having trouble logging in.
Really, Giddy? I'm an hour in, hour and a half in, and he's having trouble. I know. Now I'll give him one pass.
Thank you, Your Honor. I will call him immediately.
That's shocking that I'm doing that. Court recalls the case, People versus Alicia Williams.
Nimish Ganatra for the people.
This moment highlights something viewers often overlook: the impact of logistics and technology on real courtroom proceedings. Before this recall, the case was effectively stalled because of connection issues, freezing screens, and communication breakdowns. That might seem minor, but in a legal environment, even small delays can disrupt flow, waste court time, and affect how a defendant is perceived. Now the judge brings the case back in, giving Alicia Williams another chance to proceed. And notice the tone. It's patient but controlled. The court is accommodating but not endlessly. There's an underlying expectation. Be present, be ready, and respect the process. This also shows how modern courts operate: Zoom hearings, remote appearances, digital dependency, but with that comes risk. If a defendant appears unreliable due to technical issues, it can blur the line between genuine problems and perceived irresponsibility. So while this may look like a simple recall, it's actually a reset moment, a second chance to get things right, but also a reminder that the court is watching closely, even when the issue isn't directly legal.
Third time's the charm. Sandra White on behalf of Alicia Williams. Ms. Williams, can you state your name for the record?
Alicia Williams.
We just have to find out where that Wi-Fi works in the jail. Okay, yeah. What are we doing?
Your Honor, we would like this matter set for preliminary exam.
Preliminary exam in person will be set September 12th, 2023, 9 a.m. before Judge Burke. Bond will continue. Thank you.
Thank you.
Court calls the case, People versus James Jones. Two cases.
Nicole Hughes on behalf of the people.
Andrew Banis, Assistant Public Defender, with and on behalf of James Jones. Mr. Jones, could you unmute and state your name, please, sir?
James Jones.
See, do you have a camera, sir? Oh, there you are. Okay. All right, what are we doing?
Your Honor, I am asking for an adjournment. I think this PCC has been adjourned previously for the purpose of getting videos to my client for his review, and then to determine how to proceed after that.
That objection, probable cause September 14th, 2023, 9 a.m. Bond continued vote.
Now this situation shifts into compliance territory, and it escalates quickly. What starts as a routine adjournment turns into a discussion about a community corrections violation, and this is where things get serious. The defendant tested positive for THC multiple times and then missed scheduled tests. That combination is a red flag in any supervised release system. It's not just about substance use, it's about non-compliance. And watch how the judge handles it. He doesn't jump straight to punishment, but he makes the consequences crystal clear. No ambiguity, no room for misunderstanding. Either the defendant follows the rules or the court responds with stronger action. Then comes the key exchange. The defendant says he thought alcohol was the only restriction. That misunderstanding is critical, because in court, "I didn't know" rarely protects you. The responsibility is always on the defendant to understand their conditions. This moment becomes a warning shot. The judge is drawing a line and making it clear that if this behavior continues, the consequences won't be this measured next time.
Your Honor, could we address the community corrections violation?
Hang on. Is there one? Do I have one? I don't see, but go ahead.
Mine is dated August 24th, 2023. The defendant tested positive for THC on August 3rd and August 9th. He then missed his test on August 16th and missed his test on August 22nd. And community corrections sent us this violation.
You don't see that. So he tested positive for THC and then that. Okay. Sir, do you have a medical marijuana card?
Not right now. I didn't think it was no problem. I just thought I couldn't drink. That was it.
Well, you can't use any substance.
Okay.
So you either have to have a card or you have to do that. You understand that?
Yes, I understand now, Your Honor.
All right. I'm going to indicate the defendant, given circumstances, is admonished regarding his use of THC. No, and I'm going to indicate on the record and on the ROA, no THC without a card. So if we come back and it shows up or your levels increase, sir, then we're going to have a real problem. You understand that?
I hear you. Yes, sir.
No, you understand me.
Yes, sir.
Thank you.
And Your Honor, how soon would you like him to get over to community corrections to make up for the fact that he hasn't been there and he's missed 2 weekly tests now?
Well, I ain't got no money until till tomorrow, so I can make it tomorrow. That's why I missed the meeting. They said I couldn't drop if I ain't had $10.
Okay, so you'll have it. You get a check tomorrow, right?
Yes.
Okay. All right.
This exchange exposes something deeper than just a missed test. It reveals the financial strain behind compliance. The defendant explains he couldn't complete a required test because he didn't have $10. That might sound small, but in the legal system, even small financial barriers can create serious consequences. Now, here's the reality. The court still expects compliance regardless of personal hardship. That's why the judge sets a clear directive. Complete the test within 5 days. No exceptions, no delays. But think about the pressure here. The defendant isn't just dealing with legal obligations. He's balancing financial instability, supervision requirements, and the risk of further violations. This is where the system becomes unforgiving, because even if the reason is understandable, the expectation doesn't change. And this raises a bigger question. How many violations come from intent, and how many come from circumstances?
So he's to test within the next 5 days.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the cases People versus Susan Stratman. 2 cases.
Good morning, Your Honor.
Alex Jablowski for the people.
Hey, good morning, Your Honor. Dan Garrett on behalf of Ms. Stratman. Ms. Stratman, please state your name.
Susan Strodman.
All right. And what are we doing?
Your Honor, just about 5 minutes ago, I got an email from Ms. Sample. Ms. Stratman has been accepted into the adult drug court treatment program with Judge Kunke. I was prepared to ask for an adjournment pending that answer. I am now prepared to waive her exams, but Your Honor, I do not have signed waiver forms. Is Your Honor willing to take her verbal waivers?
Yes, yes, I will.
Please.
I have a problem with that. All right, Ms. Stratman, have you just heard what your counsel indicated?
Yes, I have, Your Honor.
Preliminary exam, and that you're waiving your right in both cases?
Yes, Your Honor.
You do understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Correct.
And you understand that by waiving that proceeding, you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Correct.
All right. People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound in case ending in 1452, bound over to circuit court on counts 1 through 3 with 4. And on the other case is bound over to circuit court on count 1 with 2 and 3 following. Mr. Garrett.
Your Honor, on all matters, we'll waive formal reading, stand mute, ask for pretrial dates in the circuit court, please. And I would like to address bond at the appropriate time.
All right. Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. So all counts. Before I say pretrial date, yes, as to bond.
This case introduces a completely different dynamic: rehabilitation versus risk. The defendant has just been accepted into a drug treatment program, which is a major opportunity. Courts often view this as a positive step, something that can lead to reduced penalties or alternative sentencing. But then comes the complication: a prior positive cocaine test and failure to enroll immediately. That creates doubt, because while the opportunity is there, the follow-through hasn't been consistent. And this is where the judge has to make a judgment call, not just legally, but practically. Can this defendant be trusted to stay compliant? Or is there a pattern of delay and non-action? So instead of granting immediate relief, the judge takes a controlled approach, denying bond reduction but scheduling a quicker follow-up. This isn't punishment, it's containment. The court is keeping the situation tight, ensuring that progress, if it happens, happens under supervision.
Your Honor, as Your Honor probably remembers and can see in its file, Ms. Stratton was remanded at the last PCC date for a positive cocaine test, as well as not immediately enrolling in Dawn Farms. She understands the importance, of course, now of abstinence. She's committed to doing whatever Your Honor orders in all bond conditions. She does have a 16-year-old daughter at home that she's anxious to get home and take care of. And now, as Your Honor has heard, she's been accepted into the treatment program. So she's got every incentive in the world moving towards that sentencing to abide by bond and to abide by all testing moving forward.
What is the end date?
September 7th is the end date.
All right, good enough. But currently she doesn't have anything in place. Is that correct?
In what respect, Your Honor? I'm sorry.
In regard to any treatment and anything at this point, she doesn't.
Mr. Oman, can you speak to that? Can you understand what the judge is asking you?
I do not understand. I'm sorry.
Are you in any treatment program or things that you have arranged for yourself to assist in your abstinence?
As of right now, I'm enrolled with Home of New Vision in therapy and have been trying to extend my services for treatment services as well.
Okay, here's the way I'm going to do it, and it may not make anybody happy, but I feel more comfortable doing it this way given what has occurred. I'm going to deny your motion for the bond reduction and give her a quicker date before the court so that something can be put into place for her so that she doesn't fall off. And I feel more comfortable doing that. So I'm going to set pretrial in this case for September 7th, 2023 at 9.
1:30 with Judge.
I'm sorry, at 4:30.
This decision reflects one of the most important roles a judge plays, balancing risk with opportunity. The defense clearly presents a narrative: acceptance into treatment, family responsibilities, willingness to comply. But the judge looks beyond intention and focuses on structure. There's no verified system in place yet, no stable framework ensuring accountability. And that's the problem. So instead of reducing bond, the judge accelerates the timeline. That's a strategic move. It keeps pressure on the defendant while also creating a near-term checkpoint for progress. This is how courts manage uncertainty, not by trusting promises, but by creating deadlines. And it sends a clear message: you don't get relief based on what you plan to do. You earn it through what you actually do.
At 1:30, what's it take? Okay. September 7th, 2023, 1:30 before
Judge Slay Thursday.
before Judge Slay on Thursday. And I think she might be asking the same questions I'm asking regarding where you are. All right, thank you.
Thank you, Your
Thank you, Your
Honor.
Honor.
Court calls the case, People versus George Dukes.
We're ready in that
I'll
matter.
use on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. George Dukes. Mr. Dukes, could you please state your name for the record?
George Dukes.
Your Honor, today is the date and time set for the probable cause conference. Mr. Dukes respectfully requests to be allowed to waive his right to preliminary examination, and he'd like to have the matter of bond addressed briefly.
Mr. Dukes, is that correct?
Yes, Your Honor.
All right, you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Brown.
Thank you, Your Honor. We acknowledge receipt of the information. We waive its reading on the record. My client will stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. As to bond before I set the pretrial.
Your Honor, we spoke of this briefly last time. Mr. Dukes had been in the hospital, had missed his date before he could make it into court. He was at hospital and he took some food from the cafeteria and got into a struggle with the cafeteria person. He's asking that the court consider allowing him a personal recognizance bond. We are confident these matters can be worked out with Mr. Dukes having a positive outcome. He promises to return to all future court dates.
It sounds to me, and I remember the bond motion, there's nothing that's changed from the last time I denied it.
Well, no, Your Honor, nothing has changed.
All right. I don't need a response. Motion for bond reduction is denied.
Thank you.
He'll have an earlier pretrial date. Pretrial.
This is a firm and decisive ruling, and it shows how past decisions carry weight in the courtroom. The defense tries to revisit bond reduction, presenting context about hospitalization and circumstances, but the judge shuts it down immediately. Why? Because nothing has changed. And in legal terms, that's everything. Courts rely heavily on consistency. If a motion has already been denied, the only way to change that outcome is to present new, compelling information. Without that, the answer stays the same. And notice how quickly the judge moves on. No extended discussion, no reconsideration. Just a clear denial and a shift toward the next procedural step. This reinforces a key principle. The courtroom is not a place for repeated arguments. It's a place for new facts.
September 11th at 1:30 p.m., Judge Slade Monday.
September 11th, 2023, 9 a.m. before, or 1:30, excuse me. I don't know why I want to do that. 1:30 before Judge Slade Monday. Right?
Thank you very much, Your Honor.
Thank you. Bond continue. Court calls the case of the people versus Eddie Wade.
Nicole Hughes on behalf of the people.
Zachary Ward on behalf of Mr. Wade. Mr. Wade, could you please unmute and state your name?
I got it. My name is Eddie Wade.
Thank you. What are we doing?
I'd be requesting adjournment. I just received discovery yesterday, and I'd ask Mr. Wade to call our office and update his phone number.
Probable cause conference, September 21st, 2023, 9 a.m. Where's your Zoom invite indicates. Bond will continue. Mr. Wade?
Yes, sir.
Do you have the public defender's office number?
I do. I just want to make a matter of the record that the officers in this case still has my phones,
Hold
so
that,
I don't.
Sir, I don't want you to talk anything about the case, anything about any evidence. I don't want to hear any of that.
No, I was just speaking about my phone, sir.
Okay, but here's what I need you to do. I need you to call the public defender's office, give them a number that they can reach you, as well as an email address that they can reach you, whether that's your phone or not, but they need to get in contact with you. Understood?
Yes, sir. Yes, sir.
You need to do that immediately after hanging up on this call.
I will.
Thank you. Bond will continue.
All right.
Thank you, Your Honor.
Court calls the case. People versus Julia Devon Martinez.
Hey, buddy.
Julia Martinez.
Nimish Ganatra for the people.
They done. They just.
And Alex Warren Green on behalf of Ms. Martinez. Ms. Martinez, would you please state your name for the court?
Devin Julia Martinez.
Where'd she go? Oh, there she is. All right. Okay, what are we doing?
Your Honor, at this time, Ms. Martinez would waive her right to a preliminary examination. I'd ask the court to bind the matter over to the circuit court for further proceedings.
All right. That's on both cases?
Correct, Your Honor.
All right, Ms. Martinez, you understand what a preliminary examination is?
Yes, Your Honor.
And you understand that that proceeding, the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
All right, you understand you'll not have that hearing on either one of these cases and you'll proceed to circuit court for further resolution?
Yes, Your Honor. I was wondering if I may speak upon one other thing.
Ms. Martinez, I think I know what you want to speak about, and I'll come and talk to you about that. I don't think we should put that on the record.
I would like to ask for a PR on the case that you're presiding upon or over, Your Honor, on account of my backed rent and as well as my phone situation that has been fixed and handled, and I will not miss another hearing at all. And I know that I'm fully confident that if you were to grant me.
And Ms. Martinez, unfortunately, we're not going to be able to talk about that until September 6th for the pretrial on that. I appreciate it, but I'll come and talk to you about that before that date, okay?
So he truly can. Like from his
I
mouth.
don't have that file in front of me. I just have these two in front of me. I realize you have other things, but this is the only file I have in front of me. These are the only two I have in front of me. And I'm trying to do the waiver on it.
If you're able, Your
Ms.
Honor,
Ms. Martinez.
you want to keep me? I would really like, I'm trying to.
Well, I'll tell you what, Ms. Martinez, I'd like for you to show up for court when you're supposed to.
Me
And
too.
repeatedly, time and time and time again, I've been dealing with you for the past. You telling me that you're going to come to court. You don't show up for court. I have to issue a warrant. We pick you up. I let you out before so that you could appear in court. And you didn't appear in court.
Your
And
Honor,
now you're asking me to change a bond on a case that I don't even have in front of me today. So to the extent that's a motion, that motion is denied.
Your
People
Honor.
waive their right.
I apologize.
Your Honor, we do waive our right on both cases. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on the felony, on all three felony counts with the misdemeanors tailing along. Counsel as to the circuit court arraignment.
Ms. Martinez would stand mute and waive any reading, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pretrial will be set in each case.
September 11th at 1:30 p.m. Judge Slade, Monday.
September 11th, 2023, 1:30 before Judge Slay on Monday. Bond will continue in these matters.
Thank you, Your Honor.
Thank you.
It is.
This final segment brings the focus back to accountability and the importance of basic compliance. The defendant explains that law enforcement still has his phone, which creates a communication barrier, but the judge immediately redirects the conversation. He doesn't engage with details about the case itself. In fact, he explicitly shuts that down. Why? Because discussing evidence outside proper channels can compromise the case. Instead, the judge focuses on what matters right now. Communication with counsel. The instruction is simple. Provide a reachable contact method immediately. This might seem like a small administrative detail, but it's actually critical. Without communication, a defense strategy can't function. Missed calls turn into missed deadlines. Missed deadlines turn into legal consequences. And that's how cases spiral, not from major decisions, but from basic breakdowns in coordination. Looking across this entire courtroom session, one pattern stands out: structure over emotion, consistency over excuses, and accountability at every level. From plea deals to probation violations, from bond decisions to scheduling conflicts, every outcome is tied to behavior, compliance, and credibility. Judge Simpson's rulings reflect that balance, firm when needed, procedural at all times, and focused on maintaining the integrity of the system. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.